In Quebec, a man accused of killing 3 people is asking for those charges to be dismissed because of unreasonable delays. Ontario's Attorney-General Yasir Naqvi says this claim is part of a bigger problem in the justice system across the country, that those strict time limits for criminal proceedings, and he's now suggesting scrapping preliminary inquiries in all but the most serious cases because he says they are slowing down the process. So joining us in studio to talk more about this is Mr. Naqvi. Welcome to us this morning.
Good morning. Thank you, Anne-Marie.
All right. First of all, for people who may not be familiar, explain the role of a preliminary hearing.
Well, so preliminary inquiries are part of our criminal justice process in cases which may be pursued by way of indictment. And the purpose is twofold. One is for discovery to take place between the Crown and the defense in terms of passing of evidence. And secondly, it's also a bit of a test on the Crown's case, whether they have sufficient evidence to prosecute a matter. That's how preliminary inquiries came about. There has been studies done over 20 years or so, which has looked at the utility of preliminary inquiries, especially in light of the Charter and the obligations under the Charter of Rights and Freedoms. Since 1991, we had far more robust disclosure of evidence from Crown to defense that takes place way before even the preliminary inquiry. So the question becomes, is preliminary inquiry as a step in certain cases is needed? Not to mention, we have improved upon our procedures to test the sufficiency of evidence that the Crown have far rigorously now than what the standard is as at the preliminary inquiry. Now, I'm not the first one who's suggesting that we should consider whether or not preliminary inquiries in certain cases needed or not. The Supreme Court of Canada in the most recent Jordan decision, where they have put in place very strict timelines for what will constitute a delay, have also suggested that maybe this is something that federal government should be looking for. These are extraordinary times. The Jordan decision, Anne-Marie, has been a game changer.
Let's explain the Jordan decision for people who may not be familiar with it.
So Jordan decision came out last July, in which Supreme Court of Canada has set very strict timelines under which cases have to be resolved. So 18 months from beginning to the end at the provincial courts and 30 months in Superior Court of Justice for more serious cases. And if you don't meet the timelines, unless there's some special exceptional circumstances, those cases can be thrown out or stayed. And we have seen that already with a case you mentioned in Quebec, in Ontario, in my hometown of Ottawa. We saw a first-degree murder charge stayed, a child abuse case stayed. That has a tremendous impact on the communities.
So then how does getting rid of preliminary inquiries get rid of that problem?
Well, so what the experts have said in looking at preliminary inquiries, that it can make the cases move faster. You can have an opportunity for cases to be resolved in Ontario Court of Justice. What I'm suggesting is that we're at a crossroad right now. We have a challenge that's been given to us by Supreme Court of Canada. They have said that the entire justice system has become too complacent when it comes to the accused's rights for a speedy trial. And in order for us to take on that challenge, we really need to look at solutions beyond just tinkering at the margin. And that is why I'm asking the federal government to bring all justice ministers from across the country together so that we can start engaging in that conversation.
All right, your critics will say that, listen, preliminary hearings help to cut time off on the back end. Yeah, sure, they take a lot of time in the beginning, but this is supposed to create less delay for an end result. What's your response to that?
Well, so we're making changes at our end as well. I brought in a bail action plan here in Ontario to make the front end of the process far more efficient, to make sure that those accused who are low risk and vulnerable can be released quicker and faster in the community under supervision, and so that we can get their cases resolved earlier. I'm not by any stretch of imagination suggesting that there's only one solution. What I'm saying, in order for us to strengthen public's confidence in our criminal justice system, in order to make sure that we really take on the challenge that the Supreme Court has given to us, that we take meaningful changes, and for that we need to bring everybody to the table.
You want the system to keep up with the times?
Absolutely.